Good morning. This is Attorney Vincent Davis, and this is The Secret, How to Fight CPS and Win. Today, we're going to talk on a very short show today about social workers and them, I guess, coming to you before a case starts and they're doing an investigation. Now, a lot of people ask me, hey, Vince, do I have to talk to the social worker? Hey, Vince, do I have to take the drug test that the social worker asked me? Hey, Vince, do I have to let the social worker talk to the kids? Um, so let's cover those three topics. And remember, I'm licensed here in California. The law may be different in your state, but check with an attorney. So number one, before a court case starts, a social worker by law is entitled to try to do an investigation. Now notice I said try to do, because when a social worker comes out to talk to you, there is nothing in the law that forces you to talk to them. All right. So please don't feel that you can talk to the social worker without any ramifications. I usually tell people don't talk to social workers without an attorney. Now, notice I didn't say don't talk to the social worker. I said don't talk to the social worker without an attorney. You are guaranteed by the United States Constitution, whenever you're dealing with a governmental agent, and it could be adverse to some constitutional right you have, like being a parent, you have the right to have an attorney present. Okay, that's number one. Number two, a social worker can never get a warrant to make you talk to the social worker. Never. You have the right to remain silent. You do not have to talk to the social worker. What a lot of people do is they believe that they can speak to the social worker, and they're trained or sophisticated enough to deal with social workers to get them off their back. I'm here to tell you that that's probably not correct. Social workers are highly trained, educated people. All right. This is their job. Their job is to get information from you and possibly prosecute you if they suspect child abuse. Now, your version of the story may not be accepted. All right. Sometimes the social workers, in my opinion, hear what they want to hear and report what they want to report. I remember I was doing a case up in Northern California, and I spoke to a witness who told me, I told the social worker ABC, but the social worker wrote down in the report that the witness said BCD, a slight variation. I don't know if it was intentional. I don't know if it was a mistake, but you see, things happen, especially when things aren't recorded, video recorded with a body cam or with an audio mic or with your mobile phone. Things get misstated. So you do not have to talk to the social worker. Number two, does the social worker have the right to talk to your children? Well, yes and no. It depends on a lot of factors. What I recommend to most clients is don't let the social worker speak to your children unless the social worker has a warrant. Now, this reminds me of a story. I was repping someone in, I think it was Ventura County, and the social worker came out and wanted to speak to the children. And we told the social worker that you couldn't speak to the children unless you had a warrant. Now, she then reached into her purse and pulled out a valid warrant to interview the children. A lot of people want to know, well, why did the social worker do that? Why didn't she just show us the warrant first? And here's why. If you give permission to the social worker to speak to your children, you have waived all rights you have. Sometimes when they get these warrants, all right, they're based upon false facts or mistaken facts. But if you let the social worker interview without that warrant, out the need of the warrant, you've waived any rights you might have to civil rights action against the social worker later. Now, the social worker can get a warrant to come to your home and inspect it. All right. So if the social worker has a warrant to do that, you have to obey the warrant. Some social workers come to your home and say, hey, can I look around? Hey, can I come inside and talk to you? No matter what the situation, the answer should be no, unless my attorney is present on the phone or in person. I know that's hard, but you've seen many, many TV movies or movies and TV shows where they say lawyer up. Okay. This is probably the most important thing in your life, your children. You want to make sure that you're doing the right thing and you're getting good legal advice. All right. So, next, can the social worker make me take a drug test? The answer is no. The social worker cannot make you take a drug test. And it's interesting how a lot of social workers play this depending on the facts and scenarios. Some social workers will just tell you, hey, you got to take a drug test. Some social workers will say, hey, will you take a drug test? Some social workers will say, I think you should take a drug test. And depending on the situation, you're likely to say, sure, no problem. Now, the first thing I want to tell you is drug tests are not 100% accurate. All right. What if you take a drug test and you get a false positive? That will be used against you. That will not only be used against you, but it might be used against you to take your children away from you. So do not take a drug test unless your attorney advises that you should. All right. The other thing about drug tests, and I was talking about someone early this morning, an old friend of mine who is an attorney who is an expert in drug testing and toxicology things and pharmacology. He actually went back to school to become an expert. You know, there are so many mistakes that can be made in the drug testing process that it's not the tool that we think it is. Now, overall, probably is, but you might be that 5% exception where mistakes are made. And then what happens? You lose your child, and that positive drug test will follow you for the rest of the case or the rest of your life. Okay, so be very careful about taking drug tests or agreeing to take drug tests. The social worker can also get a warrant to come out, usually with the police or the sheriffs, and they can take your children. Yes, they can. It's called a detention warrant. If they have previously suspected or investigated or spoken to witnesses that you have abused a child or at risk of abusing a child, they can get a warrant to take your children into custody. At that time, one of the things you want to give is you want to make sure you email or tell, I say tell, but email the social worker or text the social worker the names of relatives or family friends that could possibly take care of the children. We need to get those children in a friendly relative home right from the beginning. If your child is placed on foster care, it's tantamount to you being in jail and no bail. When you get a child out of foster care and with a relative or a friend, family friend, the dynamic of the case shifts. In other words, it gives you the leverage. But if the child is in estranged foster care and you don't know where the child is, you don't know what's going on with the child, the social worker has the leverage. Because you're probably thinking, I need to do everything possible to get the child out of foster care. Okay, here's a question from Heather Lynn Baker. How do I deal with the review hearing only reviewing what the guardian ad litem and children's services write and not reviewing any of my evidence, any of my exhibits or evidence or witnesses? Heather, that's a great question. And it talks about the answer revolves around something that I say all the time. If you go to a review hearing and the only evidence the judge has is what the social worker or the guardian ad litem has input into the case, and you don't have any evidence of your own, you're going to lose for sure. The social worker's recommendation is going to be upheld. And assuming the social worker's recommendation is not to return the child at the review hearing, you're probably going to go another 6 months without your child. So here's what you do. And it's different for different courtrooms and different in different counties. Sometimes when you go to the review hearing, and this is the way it used to be done, you show up at the review hearing, you get the report because it wasn't previously mailed to you, and you set the case for a trial where you and your witnesses and your evidence can be presented under oath to the judge to contradict whatever the social worker's saying. So you need to set that case for a trial. The newer courtrooms or the newer judges and the way they're doing these cases is you will get the report, 10 days before the court hearing. And when you show up to the hearing, the judge will expect you to be ready to go to trial on that day. So you and your attorney obviously have to speak before the court hearing, and the attorney have to discuss what witnesses need to be subpoenaed, what exhibits need to be subpoenaed, or what other evidence you have and you want to present. Okay. Um, Someone called me about a case a couple of weeks ago where they said, the visits weren't going well. Well, unbeknownst to the social worker, the parent was having visits with the child that were being videotaped by a private investigator. And allegedly, those videotapes showed that the visits were great, that the child was reacting so positively to the parent. So, those are the things that you have to do, Heather, to make sure that you get a fair shot at this review hearing. It could be set for trial, may not be, but you got to find that out from your attorney. And if it is set for trial on that date, and no date is going to be picked in the future, you got to be ready to go on that date. All right. So here we go. Chad says, Chad Easthouse, watching on YouTube. I live in San Bernardino County, California. My ex did a wellness check on me, and the police said a complaint to DCFS has been filed 2 weeks ago. CPS has not shown up or called. Should I expect them to? Yes, you should. I get the feeling, although no one's ever discussed this with me, Chad, that a lot of these calls are prioritized. Now, in your particular case, the police may have reported back, there was no problem. Kid looked fine, healthy, food in the house, that type of thing. But anytime a complaint has been filed to CPS or DCFS, someone from the agency is supposed to show up and check on the child. Now, here's something that might be affecting your case. You live in San Bernardino County, and I forget what they call CPS in San Bernardino County, but they don't call it DCFS. DCFS is a Los Angeles County name. All right. So you might be dealing with intercounty, interchanges. So DCFS might have to come out or might have to report to San Bernardino, hey, go out and look at this kid. And San Bernardino may have said, oh, you know what? The police went out. Everything was fine. We'll get out there, just not today. So, Chad, I would say, expect them. All right. Here we have Marcy McCullum. Need serious help with a question, Mr. Vince. Okay, this must be your question. Very next. It says, if we have a compliance hearing coming December 1st, we got a letter saying our investigation is closed. Does that mean we still have to follow the safety plan? Good question. And depending on how that office of CPS works, sometimes the answer is yes. Sometimes the answer is no. The problem is you actually have a hearing that's coming up on December 1st. So I would say you probably need to comply at least to December 1st. But the most important thing I would say is talk to your attorney. Okay, make sure that your attorney knows and has an answer for you because he or she is more readily familiar with, your case and what's going on. Macy, I hope that answers your question. Okay. Oh, Armanda Ministries. Good morning, Vince. Good morning, Armanda. How are you? Watching on YouTube. All right. Macy says, okay, thank you, sir, so much. All right. And Macy, the most important thing I said was talk to your attorney. All right. Because he or she is going to have more information about your case. You're just asking me on YouTube a question. I don't have all of the facts and background of the case. Remember that. I haven't reviewed the chart. But That's what I say, just based upon the limited knowledge you've given me, but always check with your attorney. All right. Getting back to the investigation. So, social workers doing an investigation before a case is filed. Typically, I think the rule says that they have about 30 days here in California to do that investigation. Does that mean they can take longer? Yes, it does. They can take longer than the 30 days. All right. And here's what happens in a lot of cases. And this has happened in a civil rights lawsuit I was involved with a few years ago. Um, the mother lived at home with her mother and three children. One of the children was a newborn, maybe a week old. And unfortunately, the child one night died, passed away. And, of course, the social workers went crazy and police started investigating. And the kid was taken to the hospital that night to try to, of course, resuscitate the child. But unfortunately, the child wasn't resuscitated. And the social workers came out and took the other two children away from the mother and placed them into, I think it was foster care, placed them in foster care. And it might have been foster care with a distant relative. I can't remember exactly. But the next day or 2 days, the doctors at this very famous hospital contact the police and presumably DCFS, but contact the police with a faxed letter and say, look, there was no child abuse here. This child died of SIDS, SIDS, sudden infant death syndrome. So I don't know if people watching have ever heard of SIDS, but you can Google it. And what basically it is, especially in newborn children, young children, they could be sleeping and for whatever reason, they pass away. It has something to do with the hearts and the lung functions. And, they just sometimes they forget to breathe. And when you forget to breathe, you pass away. So at this point, we're 1 or 2 days into it. At this point, the social workers and the police know that it wasn't child abuse. Now, the question is, did they return the other two children? And the answer is no. They didn't return the two children. And they didn't return the two children for about 7 or 8 months. They had planned to file a case in the juvenile court, giving a blessing to them taking away the other two children. But when they found out it was SIDS, there was no abuse, so there's no case to file. And so automatically you think, well, the kids should go back home. Well, they didn't go back home. So in that particular situation, and I have seen it before and heard of it before, they don't start a case, but they keep your children out of your custody. And what they did in this case is they tried to make her sign paperwork agreeing to the children being placed out of her custody. Now, she signed it, unfortunately. She didn't have a lawyer. She didn't speak to anyone. And so they were keeping the children based upon that signature. But on the reverse side of that carbon form, it said that if you ever change your mind and you want your children back, you don't want them in, custody any longer, uh, just let us know. And what we will do is, number one, we'll give you your kids back, or number two, we'll file a case and ask the judge to keep your kids in foster care. Well, this lady, a few days later, especially after she found out it's SIDS, not child abuse, she started asking for her children back. And what did CPS do in this case? They never gave her children back. They made her take classes. They made her have monitored visits, drug tests, because back in her past, there was some kind of drug incident, going years back in her past before the kid was even born. And, they were providing her services, which they were being reimbursed for by the federal government at a profit before they gave her kids back. Finally, the lady, she was fairly educated, a very college educated woman, fairly smart. She's just kept insisting and insisting. And they would have meetings with her that they would make her go to and try to sign stuff. And you know here we have a child who unfortunately passed away of SIDS. They take the other two children because of suspected child abuse, and when they learn that it's not child abuse, they don't want to give the kids back. So could that happen in your case without a case ever been filed because they're investigating more than 30 days? Yes, that could. Now, obviously, she found her way to and a very famous attorney here in Southern California who took her case, and um, something happened with his schedule, and he was in trial in another case against CPS, I might add. And he asked me to take over the case, and I did. And it came out to a great outcome for her and her children that were separated 7 or 8 months without filing a case in court. All right. So if they take your kids away, I think they have maybe 2 or 3 days to file a case. It's my opinion that you should never agree, unless I shouldn't say never, but in most cases, you should not agree to your kids being placed outside your custody without a court hearing. Because let's get everything in the open. Let's let the judge take over this case, not the social worker, and not the social worker making, random decisions, sometimes what they're not qualified to make. It reminds me of a case where CPS took away a child from the mother because they had diagnosed her on their own as social workers, not a psychologist, not a psychiatrist. They had diagnosed her with something called Munchausen syndrome by proxy. Okay. I welcome you to uh, Google that to find out what that means. But it's a very sophisticated medical diagnosis of your brain, or of psychology, right? And here these social workers were that barely had, I think a bachelor's degree, and maybe one or two of them had master's degrees, but they had no qualifications to diagnose this lady with Munchausen syndrome by proxy. And of course, she lost her case. She lost her child. The child was placed with the father. And at this point in time, the father and the mother aren't getting along, and I don't think they were ever married. And she was given visits, I think, twice a week, if I recall correctly, twice a week, monitored, for like 2 or 3 hours, something very short, maybe 4 hours. And she effectively lost her child. Went through the whole process. They proved a case against her. She had a trial. I don't I don't didn't review the transcripts, but somehow, she lost her kid by the testimony of social workers who weren't qualified to say whether someone, suffered from Munchausen syndrome by proxy. Needless to say, she looked for lawyers for several years to file a lawsuit against CPS. Uh, I have to admit, I was one of the attorneys she talked to, and I didn't end up taking her case. An attorney who she went to, I think, more than one time. I think he told me that she had actually went to him 2 or 3 times, maybe 4 times, before he decided to take on the case. He took the case, and they won a huge case against CPS for doing that. Now, here's the funny thing. When she won that case, she didn't get her kid back. The father still had the kid, and she was still getting monitored visits, even though it was presented to the family law court that she won her civil rights case against DCFS. And I know a friend of mine was her family law attorney, and I know they were battling back and forth for months about her getting more visitation, unmonitored visitation, shared custody. I don't know whatever happened in the case, but you see how things can happen and escalate and spiral out of control. Okay, here's some more questions. Macy says, "Oh, yes, I agree. I do have a court appointed attorney. I've called, left messages, and emails. I've been trying, hoping, and praying I'll get back a call tomorrow, but your advice is very helpful. Okay, Macy, I hope you're able to get in touch with your court-appointed attorney. The only thing you haven't done, and I don't know if you can do this, is text the attorney directly. But if you're sending emails, you're pretty safe because there's a documentary record of that. And Mercy says SIDS is scary. And then we have Melanie. Melanie loves Saya. SIDS is VIDS, Vaccine Infant Death Syndrome. Okay, Melanie, I'm not sure what you meant by that. And then she says, we have most people watching today on YouTube, which is interesting because we're on several other social media platforms. But welcome to everyone who's on YouTube. Healthy babies just don't die. Melanie, I welcome you to Google SIDS. Your statement there may not be correct. I'm not a doctor, but SIDS is not considered child abuse or neglect of the child. All right. Here's Armanda Ministries. You spoke with me a few weeks ago. I'm in Virginia. Hey, Virginia. I used to be in Virginia 2 or 3 times a year in Richmond, actually in another area right outside of Richmond. It's called Glen something. I can't think of the name. My adjudication got moved to November 10th. The entire affidavit is lies, hearsay, and false allegations from my husband to gain custody and leverage. Okay. Not an unusual situation, but be careful because hearsay, at least in California, I don't know about Virginia, is admissible. So if you're going to test that hearsay declarant, you need to subpoena them to court and put them on the stand and have them cross-examined by your attorney. So November 10th is, 10 or 11 days away. I would use that time wisely with your attorney to help prepare for your trial. Right. Boss Bob says, I thought something happened to my phone for a second. No, Bob, this morning, for some reason, we were having technical difficulties. So I don't know why. Armanda says, I agree with Melanie. Okay. I welcome you also to Google SIDS and see what, the authorities say about that, the medical authorities. All right. Armanda says, CPS removed all 5 of my children to foster care, mostly because we don't vaccinate and homeschool. Okay. In my opinion, at least in California, those aren't reasons to remove the children. I have heard people say, I homeschool my kids, the social workers don't like it, and they started a case against me. I think technically homeschooling is not a basis for, detention of kids. What I have seen people, get hassled about is they're doing homeschool and they're not doing it the right way. So it's technically like the kids aren't even in school. A lot of states, and I know LA County in California, they have certain requirements you have to meet, and you have to sign in and cover checklists, and you have to turn in reports. It's not just, hey, I'm going to keep my kid at home and homeschool them. There's certain things you got to do it right. The vaccination procedure, it's an interesting time we're in with COVID and vaccines and all that type of thing. In my opinion, at least in California, that whether your children are vaccinated or not is not a basis to remove the kids from your custody. That's one of those important constitutional rights that you have regarding the raising of your children. And what I have seen when it is an issue, when they get your child in foster care, of course, without your permission, they on occasion do give the kid the vaccine, even though you said, I don't want my children vaccinated. Now, is that right or wrong? Well, it definitely violates your rights. Okay. Um, but from a medical perspective, I can't really comment on that. Okay, Deirdre Payne. Good morning, Mr. Davis. Can I ask what happens if you win on an appeals case? Do your children return home or what happens? That's a very good question. I hope you are one of those people who won on an appeal case. And the answer is it depends. It depends what happens on the appeal. You know, there are a lot of things that could happen. Number one, the Court of Appeals could order that your children be returned. The Court of Appeals could order that everything remain the same except for the judge retry or have a new hearing on the issue that the court thinks was violated, at the trial court level. So it depends. If you won an appeal, it's likely you have an appellate attorney, Deirdre. So what I would do is I would contact that appellate attorney via email and say, hey, what happens now? What should I be doing? Deidre, I think you asked this question a couple of days ago, and I'm sorry I didn't answer the question, but I do recall seeing this question in, the question in the posts. So I hope I've answered your question today. It just depends, and unfortunately, I'd have to see the opinion, um, to give you further advice. But the best advice you can get is from your attorney. Now, Deirdre, if you have a California case, go ahead and email me the opinion and I'll look at it and, give you my thoughts. They'll just be my thoughts because I haven't reviewed the record. I didn't do the oral argument on appeal. So there's just me talking off the top of my head when my real recommendation is to talk to your appellate attorney. Deidre, you can email me at v@vwdlaw.com, v@vwdlaw.com, or you can give me a call on the telephone number you see up on the bottom right of the screen, 888-888-6582. Although today's Sunday and after this hearing, I'll be going to church and watching football games afterwards. So I may not be able to get to today, Deidre, but I will. A funny thing happened this morning. 5:30 in the morning here in Los Angeles. My phone rings. I look at the phone and it's a number from Florida. Now I guess it's 8:30 in Florida. It's 5:30 here on a Sunday morning. And I answer and I thought, I don't recognize the number, but must be an emergency. Somebody's calling me at 5:30 in the morning on Sunday. So I answer it and it wasn't. It wasn't the type of family emergency you might think it would have been. It was a gentleman from Florida who wanted to talk about his CPS case and, what happened and things like that. And we talked I talked to him and the mother for about 30 minutes. And, but, so when I say I can't get back to you today, doesn't mean I don't sometimes work on Sundays, but today I'm going to be busy. All right. Marcy at Melanie. SIDS is sudden infant death syndrome. A lot of it happened when a baby breathing airway gets cut off. Vaccines haven't killed babies. Do your research, LOL. I hope I'm not starting something there. Macy says at Deidre, he's made a video on his channel answering that. I'm not sure what question Macy was referring to, but you're Macy, I've made a lot of videos on my channel on YouTube. Someone told me there's like over 400 videos, and they're not really indexed any type of way. You have to just look at the titles and the comments to see if they can help you. But if I did make a video on that subject, I hope Deidre finds it. And if you want to talk to me, Deidre, you can call me at the number on the screen. And Macy, thanks for pointing that out. So we have Melanie. So it's an opinion disorder where the person has no disorder. That is a ridiculous reason to have your offspring property taken. I would concur with you, Melanie. All right, we have Armada. They are claiming I am having, quote, religious delusions, unquote, with no evidence because I run my own ministry. They took my kids, predicting I may be a, quote, mental danger, quote, no evidence, just hearsay. Well, one thing I want to tell you, Armada, is that hearsay, at least in California, is admissible against you in a CPS case. It wouldn't be necessarily in a criminal case unless it met one of those exceptions to the hearsay rule. But don't think because all they have is hearsay that you can't lose. All right, that would be a mistake, a tactical legal mistake. Armando says, I think what Melanie meant is vaccines cause SIDS. Oh, I don't know. I know nothing about that, and I'm not going to comment on that. Armana says, thank you, Vince. I took their psych evaluation at CPS last week and have 2 independent evals lined up, and my attorney has an expert to dissect theirs, curious about what diagnosis they made up. Armana brings up a really good point that I've seen a lot over my years doing CPS cases. Sometimes, they claim that, you're crazy, and they claim that they want you to take a psychological evaluation. And sometimes the judge even orders it, right? Depending on the case and the stage of the case. Now, I've heard that sometimes CPS uses psychologists that are going to rule in their favor and find you crazy. Now, I've never experienced that. I have heard of it. I have talked to other attorneys about it. And Armada has a very good strategy. She has 2 independent evaluations lined up after she does her CPS one. And I remember this happened in a case I did, I think it was in Sacramento County years ago, where we had dueling, you know, psychological evaluators. One evaluator, of course, hired by CPS, says, oh, lady's crazy. The other one said, no, there's nothing wrong with the lady, and the woman ended up testifying. She came across very well. And I think the judge ended up, ruling that, she wasn't crazy just based upon the testimony. But I think the judge in that case, and I think a lot of us, had a hard time understanding how the CPS evaluator found the lady crazy when she wasn't. It starts to make you wonder sometimes if things are really, objective. Okay, Melanie, anyone accused of a disability needs to invoke ADA rights and get an advocate. Melanie, actually, that's a very good suggestion. That's a very good suggestion. Um, before you invoke your ADA rights, the only thing that I would say is talk to your attorney, right? Talk to your attorney and make sure he or she agrees with that strategy, because that becomes part of the legal strategy. And you want to make sure that it doesn't backfire on you. I see a lot of people, and I talk to a lot of people who come up with legal strategies on their own, and they end up backfiring against them because they haven't really thought it out, right? They haven't thought it out to the end. And sometimes they don't know the laws that or the procedures that are involved. And sometimes that great strategy becomes, the best way you lose a case. So you always want to talk to your attorney. Okay, Macy says vaccines don't make SIDS occur. It could be very faulty on the parent. For one, nor supervising the baby while asleep, or packing where they sleep with too many blankets or stuffed animals. Macy, I'm not an expert on SIDS, so I'm not going to comment on that. I leave it to the professionals, the medical professionals. You might get some ideas from Google, but if you really want to know, I think there have been books and treatises written about SIDS and its cause. And from what I understand, which may not be correct, they don't know what causes SIDS. So there you go on that. Armada says psychiatry is such a subjective field. You know, I, I would agree to you to a certain extent, Armada. Any type of medical science becomes subjective. You know, sometimes you can go to a doctor, you get an opinion, and you can go get a second opinion, go get a third opinion. I myself, in my adult life, was given some medical advice that I was going to follow. And at the time, my wife was still alive, and she and it was going to lead to a major operation, and she urged me to go get a second opinion, and I did. And the second opinion doctor, who was kind of a well-known doctor in this field, um, laughed at what the first doctor said and suggested. And I was kind of scared and didn't, and was wondering maybe he's not taking this seriously. And I actually went to a third opinion, another well-known doctor in the field, and he told me after running certain tests unequivocally that the first doctor was incorrect. So, and it had to deal with my thyroid. So, and this is years ago, maybe 15, 20 years ago. So the moral of the story is it's all subjective, whether it's psychiatry or psychology or heart doctor, you know, it these people are scientists, but it's still an art. Something like being a lawyer. Okay, Deirdre says, why can't the court still allow visitation while going through in the appeals process? I assume you're talking, Deirdre, about the termination of your parental rights. And the courts still could allow visitation because once you appeal, the order terminating your rights is not final. So technically, you're still the parent when you appeal. And I think technically, you're right. They probably should be allowing visitation. But I think, they decide not to give you the visitation because they're pretty sure you're not going to win on appeal. Okay. Have I ever seen someone win an appeal on the termination of rights? Yes, I have. All right. But it's not the majority of the time. It's an uphill battle. I read something one time, just appeals in general, not even CPS appeals, but appeals in general, that there was in California, that there was less than a 5% chance of you winning an appeal. And there are many reasons for that, not only because of the law, but mainly because of sometimes the findings the judge makes in terms of facts. Generally, facts findings by trial court judges are not reversed on appeal. They're kind of written in stone. Now, there is a way for the Court of Appeals to overrule a trial court on factual findings, but it's difficult. It's a difficult road to hoe. Okay. It says foster parents won't allow it. Well, if you're on appeal, what you might, I say this again, I sound like a broken record. You got to talk to your appellate attorney or talk to your trial court attorney to find out why your visitation isn't being allowed. Okay. Um, at this point in time, the foster parents, in my opinion, don't have control of that situation regarding your visitation. Of course, they don't want you to visit because you're the parent and they don't want you to get the child back. They want to adopt the child. But unless you challenge it, like I tell people all the time, unless you challenge what they say or what the social worker says in court with the judge, you're just going to have to accept their decision. And I'm not saying you should. You should talk to your attorney about challenging it in court. All right. Okay. Well, you guys, thank you for those questions this morning. There are questions that I don't necessarily think of. Sometimes Grace and I are talking about what we should talk about on the show. And, I don't know what's in the questions of people's mind because I look at cases differently than sometimes you would look at the case. But I want to thank you all for watching today. We've come to the end of the Sunday show. Our show tomorrow will be, as usual, Monday through Friday, 7 p.m. So we hope to see you there. And if you have questions, sometimes when we don't have a guest, I can get to more of your questions. But if you have questions, come ready with your questions and post them on the social media site that you're watching on. Okay? All righty. Well, everyone have a good day today. I'm hoping that the Rams beat the 49ers today. May not happen, but go Rams. Talk to you guys tomorrow. Bye-bye.